Welcome to Bar 10 Test Prep, where we help you prepare for the bar exam 10 questions at a time. We upload content every day, so please ring the notification bell as well as subscribe so you can be updated every time we upload new content. First question on this grouping is number 1. An owner of a pizza restaurant opens a second location on a street where another owner has a burger restaurant. It seems like business is slow for the pizza place owner, and he eyes up his competitor, the burger man, as the reason. The pizza owner starts to make false statements about the burger restaurant and its inferior ingredients, which he says have been causing poisoning in some of the customers. When the burger joint owner loses customers and business income to the pizza place owner, can he sue for conversion? You have 4 options as possible answers. A, yes, because the pizza owner interfered with his right of peaceful enjoyment and disrupted his business activities. B, yes, conversion is an intentional tort and the pizza owner acted intentionally to convert and did convert part of the burger business. No, because conversion consists of appropriating another's real property. Or D, no, because there was no interference with his ownership of right of possession to his personal property. You have 10 seconds to choose the best answer. The best answer here would be D, no, because there was no interference with his ownership or right of possession to his personal property. Let's look at question number 2. A young woman became a member of a popular social media site and quickly came to notice that the site was utilizing her private information to sell to other companies for profit. The young woman was concerned because she had very strange interests and things she regularly searched. She felt embarrassed and humiliation from the disclosure. She thought there must be some compensation for the market value of the information taken from her. Will the court likely recognize these allegations as sufficient to state a claim for breach of contract? Let's look at the possible answers. Option A, yes, because the service breached the duty of good faith inherent in every contract. Option B, yes, because there are common types of damages that are authorized in breach of contract cases. Option C, no, because internet laws protect absolutely all communications and downloads of this nature as part of the service's guaranteed scope of free speech rights. Option D, no, because humiliation is not an item of damages in a breach of contract case, and the unauthorized collection of personal data does not establish an economic loss. You have 10 seconds to choose the best answer. The correct answer would be D. That would be the best of the 4. No, because humiliation is not an item of damages in a breach of contract case, and the unauthorized collection of personal data does not establish an economic loss. Let's move on to question number 3. 2 women lived in a 1-bedroom house with 20 dogs. Boy, that's a lot of dogs. A dog walker who entered the house was appalled by their living conditions. The animals' excrement was deposited throughout the house. They were kept in tiny pens, and some of the animals were sick. The visitor called animal control. A state law authorized humane societies to receive abused or neglected animals from animal control officers, to care for them and adopt them out. The SPCA took animals designated by the officers. The officers then arrested the women for animal neglect. At a hearing, the prosecutor is unprepared and the judge dismissed the charges. The women then sued the officers and the SPCA under 42 U.S.C. Section 1983 for civil rights violations. Animal control moved to dismiss, arguing they were not a state actor. Which do you think is the most likely result of that application? Option A. Would they be found to not be a state actor because there was nothing that was done by the Humane Society that involved police action? Would the application be granted because the SPCA personnel did not at any time act under color of state law? No, because the SPCA was organized under a nonprofit certificate of incorporation that was issued by the state. Or no, because the SPCA acted under the authority of the state statute and cooperated with state authorities to perform the authorized functions. You have 10 seconds to choose the best answer. Correct answer is D. No, because the SPCA acted under the authority of the state statute and cooperated with state authorities to perform the authorized function. As a result, their motion would not be granted. Let's look at question number 4. Person robbed and could only see the robbers. A person was robbed and could only see the robber's eyes, as robber was covered by a hoodie and a face mask. Based on the limited evidence and facts, police make an arrest of Robert. Robert was then presented as the robber. Robert is presented in chains and prison clothing. He was presented to victim and told this was the person they arrested for his robbery, and asked did he recognize Robert. Was the presentation of the robber proper? A. No, because it's not reliable enough and there was too much suggestion to make a reasonably accurate identification. B. No, because prior statements of identification are considered hearsay and never allowed into evidence. C. Yes, if the witness perceived the perpetrator by seeing his eyes and made the identification on that basis, it was reliable enough to be admitted. And finally, option D. Yes, because the witness's recognition of someone is all that is needed. The reliability or credibility of it is subject to cross-examination. Take 10 seconds and see if you can choose the best option. The best answer is A. No, because it's not reliable enough and there was too much suggestion to make a reasonably accurate identification. Let's move on to question number 5. A female employee was fired as an executive assistant when she was 7 months pregnant. She brought a Title VII civil rights action in federal court for gender discrimination against the employer. At trial, a former coworker was not allowed to testify that she heard a human resources person note she and another employee were fired due to pregnancy complications. The witness was a vice president of the company and an advisor to the president. Without the benefit of that vital testimony, the jury found for the employer. On appeal, the plaintiff argued that the testimony should have been allowed and that it was not hearsay under the federal rules. Will the court likely grant the appeal and order a new trial? A. No, because the statement is clearly hearsay with no exception to the hearsay rule being applicable. B. No, because it was based on things that the coworker heard from others, making double hearsay that is never admissible. C. Yes, because that kind of testimony is reliable and not excludable as hearsay. D. Yes, because it is admissible under the spontaneous utterance exception to the hearsay rule. 10 seconds to choose your answer. Correct answer is C. Yes, because that kind of testimony is reliable and not excludable as hearsay. Let's look at question number 6. A martial arts student worked very hard to strengthen her legs, including performing additional activities such as leaping and bouncing up multiple flights of stairs in her apartment building. While she was performing her exercises, one of the janitors in the building warned her that she was bound to get hurt if she keeps it up because there are some problems with the floor. After falling and breaking a leg due to a loose floorboard, she brought suit against the building owner. The building owner wants to testify that the janitor told me. I told her that running too fast is dangerous, and she was bound to get hurt. Is the building owner's statement likely to be held admissible? Let's look at our 4 options. A. Yes, because it is an exception to hearsay as a spontaneous declaration to an opponent party. Option B. Yes, because the building owner can testify and be questioned about what the janitor told him. Option C. No, because it's irrelevant and immaterial. And D. No, because it is hearsay within hearsay and there are no hearsay exceptions that apply. Take 10 seconds and see if you can choose the best answer. D would be the best answer. No, because it's hearsay within hearsay and there are no hearsay exceptions that apply. Let's look at question number 7. Buyer asked manufacturer to make him 1,000 items for $10,000. Buyer intended to retail them by mail order sales. The items had to have the buyer's logo imprinted on them. The manufacturer, as a result, ordered the raw materials and made a new item mold that contained buyer's logo. The buyer wanted quick delivery of at least 1,000 of them right away. The manufacturer rushed the order and sent 1,000 conforming items 2 days later. The buyer paid for the items but rejected delivery on the remaining 9,000 items. The manufacturer filed suit and claimed damages for breach of contract. Defendant buyer filed a motion to dismiss the complaint on the basis that the statute of frauds was violated and that it was a contract for over $500 that was unenforceable under state law. Will the court likely grant the motion to dismiss? Let's look at our four options. A, yes, the statute of frauds must be enforced when it involves goods over $500. B, yes, the manufacturer did not protect its interests by agreeing to an oral contract and it must pay for its bad business practices. C, no, because there's an exception for goods that are specially made for a buyer. And D, no, the law will enforce the benefit of the bargain rule. Take 10 seconds and see if you can choose the best answer. The best answer is D, no, because there's an exception for goods that are specially made for the buyer. Here, the fact that there was a specific mold, and that mold incorporated the logo for buyer, that can be seen in essence as a custom job. Question number 8. Two friends have been living together and decide to get married. The man asks the woman for a prenup, which says his property that he now owns will remain in his name if they ever get divorced. She agrees to that, but demands a written document. However, they get married without having signed this document or any document along those lines. 3 months later, husband leaves wife for another woman, an older friend. He sends her notice to leave the home due to their prenuptial agreement. She refuses to leave, and husband filed suit. Will the prenuptial agreement be enforced? A, yes, because the consideration for the contract was the marriage, and the consummation of the marriage made the contract complete and enforceable. B, yes, because prenuptial agreements are given the benefit of the doubt when it comes to enforcement decisions. C, no, because a contract in consideration of marriage must be in writing and the prenuptial was therefore not legal as long as it remained oral. Or D, no, because husband did not live up to his promise to put the agreement in writing and therefore he was guilty of fraud. You have 10 seconds to choose the best answer. Best answer is C, no, because a contract in consideration of marriage must be in writing and the prenuptial was therefore not legal as long as it remained oral. Let's move on to question number 9. Mr. Burns owns a nuclear plant in Springfield. Homer, Bart, Lisa, and Flanders took residence under a bridge on the property of Burns. Smithers, the COO of the plant, was aware of the fact that the above took residence on the land because in fact Homer is an employee of the plant. The water on the land, which was used for dumping by the plant, had been used for drinking water as well as fishing by the Simpson family. To wit, as a result of poisoning, Homer dies. Marge files suit. Does she have a leg to stand on? A, yes, because even though they trespassed, the owner had a duty to warn because it knew that they were in danger. B, yes, because the owner was strictly liable for any injuries caused by the hazardous condition of the water on the lake. C, no, because owner owes no duty to trespassers except if it acts with willful or wanton disregard. And D, no, because as an owner of land, they never have to worry about protecting the safety of trespassers. Take 10 seconds and choose the best answer. Best answer is A, yes, because even though they trespassed, the owner had a duty to warn because it knew that they were in danger. Here the key issue is that they knew of the danger, so the danger was not an unknown. Final question in this grouping. Number 10. Bob, a teenager, walked his dog down the road on a daily basis. One day, Teaker, the dog, gets free and runs into a neighbor's property. Neighbor was a cranky old person and called the police and charged Bob with trespassing. Bob is convicted at the trial level but appeals. Is his appeal likely to succeed? A, yes, because he had a limited privilege to enter the land to prevent harm to his chattel. B, yes, because the tender pet doctrine allows temporary entry to retrieve baby animals. C, no, because the neighbor had a right to keep any living chattels that crossed onto his land, or D, no, because his status as a breeder made him unqualified for a limited license. Take 10 seconds and choose what you think is the best answer. The best answer is A, yes, because he had a limited privilege to enter the land to prevent harm to his chattel. In essence, he was simply following the dog, which is his property, and solely attempting to recover his property. Thank you for joining us on day 2. Again, as I noted before, please subscribe and ring the notification bell so that you can be updated every time we upload new content to this channel.